Under Article 84 of the Labor Code, hours of work shall include all time during which an employee is required to be on duty or to be at the prescribed workplace, and all time during which an employee is suffered or permitted to work. Rest periods of short durations during working hours shall be counted as hours of work. These are coffee breaks, which does not exceed 15 minutes, are considered rest periods. Coffee breaks shall be considered hours of work. Now, what is the normal hours of work? Under Article 83 of the Labor Code, the normal hours of work shall not exceed 8 hours a day. The next question now is, why do we have to determine the hours of work? To determine the hours of work is very important. Why? In relation to the wage that the employer shall pay to the employee, we have to determine the amount of wage to be paid. For instance, if the employee worked below 8 hours, then there will be undertime and the wages will be correspondingly reduced. Also, if the employee renders work beyond 8 hours, then the employer shall give the corresponding overtime pay. In order to be guided, you have to resort to Section 4, Rule 1, Book 3 of the Implementing Rules of the Labor Code, which provides the principles in determining whether or not the time spent of an employee is considered hours of work or hours worked. 1. All hours are hours work which the employee is required to give his employer, regardless of whether or not such hours are spent in productive labor or involve physical or mental exertion. Letter B. An employee need not leave the premises of the workplace in order that his rest period shall not be counted, it being enough that he stops working, may rest completely, and may leave his workplace to go elsewhere, where within or outside the premises of his workplace. Letter C. If the work performed was necessary, or it benefited the employer, or the employee could not abandon his work at the end of his normal working hours because he had no replacement, all time spent for such work shall be considered as hours of work, if the work was with knowledge of his employer or immediate supervisor. This is the case of overtime pay or overtime work. Another, letter D. The time during which an employee is inactive by reason of interruption in his work beyond his control shall be considered working time, even if the imminence of the resumption of work requires the employee's presence at the place of work, or if the interval is too brief to be utilized effectively and gainfully in the employee's own interest. So those are the guiding principles to determine whether or not the time spent by the employee is considered hours of work. The next question would be waiting time. Is waiting time compensable? Under Section 5 of the said rule, waiting time spent by an employee shall be considered as working time if waiting time is an integral part of his work, or the employee is required or engaged by the employer to wait. An employee is required to remain on call in the employer's premises or so close thereto that he cannot use the time effectively and gainfully for his own purpose shall be considered working while on call. An employee is not required to leave a word at his home with the company officials where he may be reached is not working while on call. Those are the rules on waiting time. Regarding lectures, meeting, and training programs, attendance at lectures, meeting, training programs, and other similar activities shall not be counted as working time if all of the following conditions are met. 1. Attendance is outside the employee's regular work hours. 2nd, attendance is in fact voluntary. 3rd, the employee does not perform any productive work during such attendance. So these 3 requisites must be present. If training or seminar is conducted pursuant or in relation to the job performed by the employee, then it's considered hours of work. If it is done outside the company premises, if it is sanctioned by the employer, then it is considered hours of work. So if the attendance of training seminar exceeds 8 hours, and if it is compensable, then the employee should be entitled to overtime pay, because this training or seminar will benefit the employer, not the employee. Also, there will be question on travel time. Is travel time compensable? If you travel from home to work, definitely it's not compensable. But if you travel all in day's work, it is a compensable hours of work. While you are traveling, going to the field, it will take you 12 hours traveling. Then it's considered compensable hours of work. If you travel away from home, the nature of the job of field employees, then travel away from home is considered compensable hours of work. Now, one amendment in connection to hours of work, or one innovation, is brought about by Republic Act 11165, otherwise known as an act institutionalizing telecommunication as alternative work arrangement for employees in private sector. This is otherwise known as the Telecommuting Act. Now, this is only voluntary, because under Section 4, the employer in the private sector may offer a telecommuting program to its employees on a voluntary basis, and upon such terms and conditions as they may mutually agree. However, it shall be ensured that the employee shall be entitled to the same terms and conditions as regards compensable hours of work, minimum number of hours of work, overtime, rest day, and entitlement to leave benefits. We have Department Order 202, Series of 2009. So if employer and employees agree and enter into a telecommuting agreement, or even in a policy, this agreement shall stipulate any of the following. When you say any, meaning you enumerate but not limited to, also as defined in this second paragraph of DOLE Department Order number 202, Series of 2019. You have to include the provision on eligibility, the applicable conduct or code of conduct and performance evaluation and assessment. You have to deal with appropriate alternative workplace or workplaces, the use and cost of equipment, work days or hours, conditions of employment, compensation, benefit, particularly those unique to the telecommuting employee. There should be non-diminution of benefit. Then the employee should observe the data privacy, because the work is done outside the company premises. Also, you can include dispute settlement and termination or change of work arrangement. Now, what should be required here? There is Section 5 of RA 1165. The employer shall ensure that the telecommuting employee are given the same treatment as that of comparable employees are given the same treatment who are working at the time at employer's premises. So if what the employee working in the company premise or premises, the telecommuting employee should receive the same. For example, the rate of pay, overtime pay, night shift differential, rest period, regular holidays, etc. That's under Section 5, or the fair treatment rule. Now, is the obligation of the department, the employer, to notify the Department of Labor as regards the adoption of telecommuting work arrangement by accomplishing the duly prescribed report form. So you have to remember that this Telecommuting Act is voluntary, but once employer and employees agree to apply the provision of the law, then there's an obligation to report the same to the Department of Labor. That's under Section 7 of DO 202 series of 2019. This telecommuting arrangement has been applied to several companies, especially during the pandemic, because the employees are not allowed to go out of their residences due to the quarantine policies of the government. So this has become relevant during the COVID pandemic. Another topic would be compressed work week. Under the Dole Advisory Number 2 series of 2009, there is the provision here on how to avail of compressed work week. There are also companies who availed of compressed work week because of the COVID. Instead of employees working from Monday to Friday, they reduced their normal work week from 6 days to 5 days, and even some are on rotational basis. So when you say compressed work week, this refers to an arrangement where the normal work week is reduced to less than 6 days, because as we all know, the normal work week of an employee is 6 days with one rest day, 24 consecutive hours after the 6-day work. So when you reduce the work week to less than 6 days, the total number of work hours in a week, which is 48 hours, shall remain. So what will happen with that would be, if the compressed work week will be applied, the employees will work only for 5 days, and the hours of work will be 12 hours without overtime pay. However, this normal work week shall not last for more than 6 months. And there's also the obligation of the employer to notify the Department of Labor through the regional office, which has jurisdiction over the place, as regards the adoption of the flexible work arrangement. And they shall use the report form as provided in that advisory. When is compressed work week prohibited? Under DO 174 series of 2017, Section 9 thereof, it prohibits compressed work week schemes in which employees are exposed to airborne contaminants, human carcinogens, substance, chemicals, or noise that exceed threshold limit values or tolerance level for an 8-hour workday, as prescribed under the Occupational Safety and Health Standards. So that's the only instance when compressed work week is prohibited. Now let's go to rest day. Under Article 91 of the Labor Code, it provides, it shall be the duty of every employer, whether operating for profit or not, to provide each of his employee a rest period of not less than 24 hours, consecutive hours, after every 6 consecutive normal work days. Then the employer shall determine and schedule the weekly rest day of his employee subject to collective bargaining agreement and to such rules and regulations as the Secretary of Labor Employment may provide. However, the employer shall respect the preference of employees as to their weekly rest day when such preference is based on religious ground. So as regards rest day, it doesn't mean that the rest day will be Saturday or Sunday, because the law does not provide. The law only provides a rest day period of not less than 24 hours, a consecutive 24 hours after every 6 consecutive normal work days. Regarding preference of religion, since according to second paragraph, it must be respected, if the preference of the employees to his weekly day of rest, like for example the religion, we all know that Seventh-day Adventists respect Saturday as their worship day. So there's the rule for that under section 4 rule 3 of the implementing rules of the labor code. According to that rule, second paragraph, where the choice of the employee as his rest day based on religious grounds will inevitably result in serious prejudice or obstruction to the operation of the undertaking, and the employer cannot normally be expected to resort to other remedial measures, the employer may so schedule the rest day of his choice for at least 2 days in a month. You have to take note also of Article 92 of the Labor Code in connection with this rest day, and Rule 3, Section 4 of the Implementing Rules and Regulation, wherein the employer may require its workers to work on the rest day. There is the enumeration therein to mention, in case of actual or impending emergencies caused by serious accident, fire, flood, typhoon, earthquake, pandemic, and other disaster or calamity, to prevent loss of life and property or imminent danger to public safety. In case of urgent work to be performed on the machinery, equipment, or installation to avoid serious loss which the employer would otherwise suffer. In the event of abnormal pressure of work due to special circumstances where the employer cannot ordinarily be expected to resort to other measures. Another, to prevent loss or damage to perishable goods. Another one, where the nature of work requires continuous operations and the stoppage of work may result in irreparable injury or loss to the employer. And lastly, under other circumstances analogous or similar to the foregoing as determined by the Secretary of Labor and Employment. So that's rest day. So if ever there's a question on this topic, it will be based on the religious ground. A hypothetical case where the employees are demanding for a specific day in a week as their rest day based on religious conviction. So we will apply, no? Especially if the choice, it's okay if the employer will allow, no problem, that's the management prerogative. However, if the choice of the employee would affect, or result to prejudice or obstruction to the operation of the company, then only 2-day rest day period will be given to the choice of the employee or the employees. So in the case of Seventh-day Adventists, they will get 2-day rest days on Saturdays, and the other rest days will be determined by the employer. Let's go to meal break. Under Article 85 of the Labor Code, it shall be the duty of every employer to give his employees not less than 60 minutes time off for their regular meals. So do not consider this privilege or this right, no, not privilege, but right under Article 85 as lunch break, because meal break doesn't mean only lunch break. It could also mean dinner. So what is now the rule? First, it should be 1 hour. However, if it is less than 60 minutes or 1 hour, there are two classifications here. If it is less than 1 minute or less than 1 hour, but not less than 20 minutes, it will be considered compensable if the work is non-manual in nature and does not involve strenuous physical exertion, or where the establishment regularly operates not less than 16 hours a day. Another, in case of actual impending emergencies, there's urgent work to be performed on machineries, equipment, or installations to avoid serious loss which the employer would otherwise suffer. And lastly, where the work is necessary to prevent serious loss of perishable goods. So that's the first instance when meal period is reduced to 60 minutes but not less than 20 minutes. So those are the requirements. So any of those, no? The other scenario, when it is compensable meal period, is when the meal break is less than 20 minutes. So it will be considered compensable. Rest periods also, or coffee breaks running from 5 to 20 minutes, are considered compensable working time. In the case of Philippine Airlines versus NLRC, February 2, 1999, the Supreme Court ruled that there is no abandonment if during meal break the employee will go out from the company premises and return thereafter, or prior to the expiration of the 1 hour, in order to buy something or to do something outside the company premises. So there is no abandonment. So that is the rule. Another rule that you have to remember would be the work week in case of hospital personnel. They have a special provision under Article 83 of the Labor Code. There's the provision here that the work of hospital personnel shall not exceed 8 hours a day. And the number of the work days in a week will matter, will vary. Regarding health personnel in cities and municipalities with a population of at least 1 million or a bed capacity of at least 100, they shall hold office only for 8 hours per day for 5 days a week. Below that, then there will be 8 hours per day and 6 days in a week. So the reason is that they should not be overworked because they are dealing with health and life of patients. So we don't have the problem as to the determination of population because we have to rely on the Philippine Statistics Authority. On the other hand, the determination of bed capacity of a clinic is determined by the Bureau of Medical Services pursuant to Republic Act 4226, otherwise known as the Hospital Licensure Act. And that will be the basis to determine the actual bed capacity of the hospital or clinic. So if you will be asked of the hours of work of the hospital personnel, they perform 8 hours a day, but the number of rest days would vary because if the population exceeds 1 million or the bed capacity exceeds 100, then they will work only for 5 days and there will be 2 rest days. Let's go to overtime. Under Article 87 of the Labor Code, work may be performed beyond 8 hours a day, provided that the employee is paid overtime work, an additional compensation equivalent to his regular wage, plus 25% thereof per hour of work. If overtime is rendered during rest days or holidays, then the same shall be paid at least 30%. What is this prohibition of offsetting of overtime by undertime? Article 88 provides that undertime work on any particular day shall not be offset by overtime on work on any other day. Which means that if there is undertime today, it cannot be offset by overtime tomorrow. If the employer will agree the undertime today can be offset by overtime today, that is allowed. It's like flexible hours of work. What is prohibited here is overtime or undertime is offset by overtime in different days. So overtime performed, undertime committed today cannot be offset by an overtime work to be performed tomorrow. That is not allowed. Article 89 will provide you of instances when the employee will be required to work overtime. So go over examples of which when the country is at war, where it's necessary to prevent loss of life or property, when there's an urgent work to be performed on machines or installations or equipments in order to avoid serious loss or damage to employer, and some other causes of similar nature, or when work is necessary to prevent loss or damage to perishable goods, or when the completion or continuation of the work started prior to the 8th hour is necessary to prevent serious obstruction or prejudice to the business or operation of the employer. For purposes of computing overtime under Article 90, the regular wage of an employee shall include the cash wage only, without deduction on account of facilities provided by the employer. So if it is 404 per day, then 404 will be the basis for computation of overtime work. The Supreme Court, in the case of Robina Farm Cebu et al. Versus Villa, April 18, 2016, ruled that entitlement of overtime pay must first be established by proof that overtime work was actually performed by the employee. The burden of proving the entitlement of overtime pay rests on the employee because the benefit is not incurred in the normal course of business. The court ruled that failure to prove such actual performance transgresses the principle of fair play and equity.